Okay, let's get started. Welcome, everybody. The HRW COVID team is coming to you from the Don Cesar Hotel in St. Petersburg, Florida. And through just the wonders of technology, we can all be together. For the last few months, the HRW counseling team has been fielding questions day in and day out from clients about COVID-related issues. We were thrilled when our colleagues Kathleen Burney and Mark Mackey, both of whom are active members of our COVID counseling team, came up with the idea to do a webinar to provide high-level information on being a responsible, legally compliant employer in this ever-changing world of COVID. Before I turn the reins over to them, let me tell you a little bit about each of them. Kathleen focuses her practice on counseling and litigation. If you've had the good fortune to work with her, you know she's a thoughtful, practical, and careful, drawing on her experience not only as a small business owner, but we stole her from Raytheon, where she was a paralegal and then a lawyer. She's also a scholar, having clerked with the Mass Appeals Court. Mark Mackey is one of our hometown Boston gents, and he does both counseling and litigation and serves clients in a wide range of industries, including working with the Associated Subcontractors of Massachusetts members who are on the line. He was named a Massachusetts Rising Star by Super Lawyers last year, and we could not agree more. His last job was working for a firm that represents employees and unions, so he understands the perspective of both workers and management and how to bridge that gap. He too has some scholarly credentials, having interned with the First Circuit Court of Appeals. So without further ado, I turn it over to Mark.
Thank you, Dave, and good morning, everyone. Thank you for joining Hirsch Weinstein for our Return to the Workplace webinar. My name is Mark Mackey, and I'm joined today by my colleagues Kathleen Burney, Kathy Rubin, and Dave Wilson. Today, we're going to answer a question that's on all employers' minds. What do I need to do to reopen my workplace in light of COVID-19? There's been a lot of guidance and standards that have come out about what companies should do or need to do in order to reopen. We'll be going over some of the most relevant topics to help guide you in complying with the guidance and standards, and also discussing other considerations that go into reopening the workplace. A few housekeeping items to go over before we get started. We'll be sending out a PDF of the slideshow presentation to all registered attendees after the webinar, along with a helpful handout. Attendees will be muted throughout the webinar, but if you have any questions during the presentation, please submit them through the chat. Kathy Rubin and Dave Wilson will be staffing the chat to answer those questions. So big thanks to Kathy and Dave for doing that. We'll also have some time at the end to answer questions. And just so everyone's aware, we're going to be recording the webinar, and by staying on the webinar, you're consenting to the recording. I'm now going to turn it over to Kathleen for some more introductions.
Thanks, Mark. So just a brief preface, there are a lot of different safety standards out there. In fact, almost 30 of them, depending on the sector you work in. Thus, the presentation today is really general. Some of it may or may not apply to you. And of course, it's a snapshot in time in this ever-changing COVID landscape. So please do participate, ask your questions, but understand that this is subject to change and may not specifically apply to your business. Next slide, please. Okay, Mark.
Yep, thanks, Kathleen. So a lot of what we're doing here today boils down to an employer's duty of care to keep their employees safe at work. Of course, we all want to avoid liability where possible, but the steps we're encouraging employers to take are not just about complying with the requirements. It's also about working diligently to prevent COVID in the workplace and keep employees safe. Today, we'll go over actions employers should be taking to satisfy their duties to employees in light of COVID-19. Next slide, please. And to give you an overview of what today is going to look like, Kathleen will start out by talking about the steps employers should be taking before reopening the workplace to employees. I'll pick it up from there and talk about the workplace policies in light of COVID. then turn to what an employer should do if an employee refuses to return to work. We'll close out with a discussion about liability in the workplace before opening up for questions. And with that, I'm going to turn it back over to Kathleen now to talk to you about your return to work plan.
Thanks, Mark. So any good plan, building a house starts with a good foundation. So let's lay the foundation of where we are right now in the Massachusetts reopening. As you, I'm sure, know, Governor Baker had appointed a reopening advisory board who rolled out the reopening plan in March. That went into effect May 25th. And perhaps you were one of those businesses that actually operated throughout the pandemic as an essential business with essential workers. All workers in Massachusetts are required to abide by the safety standards when their business reopens. That means that if you operated all along, as of May 25th, technically that was the date for all already operating businesses to have their safety plan, their control plan, their attestation poster in place. If you haven't done it yet, we certainly advise you to get going on that. And then for the rest of us, you likely know that where we are right now is phase 3, step 1. We've been there since July 6th, and Governor Baker has paused on moving into step 2 of phase 3 until some of the numbers go down. And of course, that impacts what businesses can or cannot operate. I'm a triathlete and a marathon runner, and every race is canceled. It's stage 4. As you know, public outdoor theater events, many things aren't happening yet until we move to the next phase of reopening. So you want to reopen your business. Where do you start? This is where I start when clients ask me, what do I do? Start out with these broad overarching principles and questions, the 5 W's with an H. So what type of business are you will lead every decision you make with respect to opening up safely and complying with the standards. If you're an essential business, you've been operating, we already talked about that. There are almost 30 sector-specific guidelines and protocols on the Massachusetts reopening website. If you're a car wash, there are sector-specific protocol for you. If you're in childcare, if you're in health and human services. So the first place to go or to think about is, what sector am I in? Even if your business doesn't align with those listed by Massachusetts sector-wise, there are universal standards that apply to any other business. So one way or another, bottom line, you're covered. You need to think about and act on these safety standards. So when is your business able to reopen? I already talked about that a little bit. You, I'm sure, know quite well where you stand. If you're a restaurant, if you're a fitness center, if you're a massage therapist, if you're in the construction industry, it depends on what your sector is as to when you were opened for business. Where you're located may make a difference. For example, if you're a commercial space or an office located in Boston, the city of Boston has published operational recommendations for commercial spaces that work alongside the Massachusetts safety standards. So you'll want to consult those. If, for example, your business is in Somerville, Somerville has lagged behind the rest of the state in terms of its reopening due to concerns of infection rate, and in fact has stalled there or paused on reopening to phase 3 4 times now. So check your local town reopening website, many of them have it, and figure out if anything applies. How do you apply? Well, that's what we're going to touch on, the $50 million question in the next few slides. And when or why you should reopen or should you reopen certainly is a business-driven question that only you can answer. And hopefully today will give you some more food for thought about next steps. Next slide, please. So a roadmap to reopening. So let's fast forward the tape to where you want to get to be compliant on paper. Massachusetts requires you to, per your sector, complete a safety control plan. Once you've completed the control plan and have put into place all the measures that the control plan requires or urges you to in certain instances, you then need to go on the website. There's an attestation that you self-certify that you have in fact done what the safety standards require you to do. You'll be required to post that attestation on your site premises where your employees and visitors can see it, somewhere in the front perhaps. You'll also need to maintain a copy of your control plan in the event, as the safety standards put it, in the event of a breakout on your site, a COVID breakout that is, or in the event of an inspection. So that's the end game for, bottom floor compliance. To get there, really helpful in our experience when we see workplaces, when we see our clients have one or two people who are deemed the coordinators. So no death by committee, you have one person or a small group spearheading the effort, making the decisions. Once you've got it all in place, part of the safety measures require you to train your employees on certain things, communicate them. As always, you want to let them know what's going on, and then you'll be ready to reopen. Next slide, please. So speaking generally about the safety standards, no matter what sector you are in, they fall into these 4 pillars: social distancing and face coverings, staffing and operations, hygiene protocol, and cleaning and disinfecting. Employees require training on all of the above before you reopen. So next slide, please. It seems in my experience when working with clients reopening, the social distancing pillar is the intuitive place to start. We all understand that at this point. We've been hearing about it for a long time now from the CDC. Governor Baker issued his face covering order, and you in the workplace must ensure that that 6-foot distance is maintained between your employees and staff and visitors or the public. And when that can't happen, that face coverings are worn by all. So that seems like a real tangible place for many of my clients to start. They start off with that face covering, that social distancing policy. That, of course, cascades a whole bunch of questions about what you do in your workplace, what you do physically, what kind of signage you're going to put up. Will you have one-way hallways? What will you do about common spaces? There's an apartment building down the block from me that has tape over all of the benches, and any chairs or any public thing that was movable has been either locked down or turned upside down, so that it's very clear you're not going to sit on this. So what do you need to physically do in your workplace? And what do you need to do to make sure that people understand that? In the beginning, when people do return back to the workplace, remember, we might be used to it at home, but if you're transitioning into the workplace, this is very new to many of your folks, and you'll want to have those notices on the door: stop here, checklist, what do they need to do? When it comes to scheduling, you may, depending on the number of employees that work for you, have to do a rolling schedule. Perhaps your building you can't meet safety standards with your full workforce in the building. For example, the office spaces mandatory safety protocol allows only 50% of your certificate of occupancy. That's the number of people that you're allowed in the building, or no more than 10 people per 1,000 square feet. Now, there are ways that you can, try and, for hardship's sake, get around that. But generally speaking, if you've got too many people, you might have to have a rolling workforce in terms of remote or in office. Next slide, please. So moving into staffing and operations, and this is where I'm going to spend the most of my time. There are a few big buckets of must-have policies that I've worked with employers on and that you're going to want to think about. And they are what to do when employees show up for screening purposes, so health screening, what to do, number two, if someone in your workforce does test positive for COVID. Number three, what do you do about bringing that person back into the office? What is the return to work plan in the event of a COVID positive incident in your workplace? So let's start with the health screenings. Employers have been asking us, what can I do and what can't I do? This balance between employee privacy and living in the midst of a pandemic. Well, the Equal Opportunity Commission has issued some very helpful guidance to all of us that makes it clear that employers can do things that ordinarily they may not have. You are permitted to ask questions about an employee's health because we are in the midst of what the WHO has declared a worldwide pandemic. The EEOC has said that a pandemic, COVID-19, is a direct threat to the workplace and to safety, thus the permission to ask certain questions that one typically wouldn't. So a temperature check is one way that some of our employers are doing this. You'll have to decide pretty much all of these policies and protocols will be driven in part by your culture, your physical space, your client base, etc. We're simply giving you some ideas. Other of our clients have done health screenings. The safety standards says that you must screen employees, and it gives you a whole list of the questions that you need to ask them. Next slide, please. About whether they've been COVID positive themselves, whether they've been exposed to someone COVID positive, questions like that. So think about what you need. Some employers are doing both thermometer, temperature, and screenings. And so now, second point, what will you do in the event that an employee tests positive? Now, this is definitely something that you need to think about before it happens, because I have clients who have very clear plans that they've had in place since May, but still, when you get that phone call about an employee telling you that they either think they are, or they're positive, or they're waiting for the test results, etc., it's intimidating. So you want to go to your plan and follow it. So what do you follow? What do you do for your plan? Good idea to implement contact tracing in the workplace. Some way to keep track of the comings and goings of your staff. For some employers, perhaps it's just as easy as using their login and log out if you don't have any other public or visitors in the workplace. Others have sign-in sheets, or to avoid paper as is encouraged, they have or requesting that employees send emails saying, hey, I'm here, or hey, I'm leaving. So think about how you'll trace your workforce in terms of their movement in and out of the site. And again, if you have more than one site, you've got to think about this in multiple different ways. If you do have an employee test positive, the safety standards say that you shall actually notify the local Board of Health. The EEOC has expressly stated that you are permitted to provide the employee name to the Board of Health. And of course, they then will do their contact tracing work in the background. For you, the next question is, who did this employee have close contact with, if anyone, in our workplace? Now, close contact is a term of art. It's not, it is defined as within 6 feet for 15 minutes or more of someone who's positive or presumptively positive. So that doesn't mean that simply because somebody in the workplace walked down the hallway for 5 seconds in and out of the building, or a UPS driver in and out of the building, that doesn't mean that everyone in your workforce needs to be notified. So there's that reasonable assessment of who was in close contact. And then when you do tell your employees that they may have been exposed to the virus, you will not use the name. The EEOC has very clearly said that employers should maintain that confidentiality. And that means that if you've got a work site with 3 people and it's very obvious that one person is out, still, you keep that name private. And in your dealing with that information regarding that employee, you treat that as medical information with a confidential need to know list within your office, and it doesn't go in their personnel file. None of the information, no health screenings, nothing about them being COVID positive. So if you do have someone positive and you do establish there was close contact, you'll also want to look at whether you need to do a disinfecting and cleaning of your work site. The CDC says that if they've been on site within the last 7 days, that some cleaning is required, disinfecting is required, and they provide the information as to how to do that. Next slide, please. Now, this is a very busy slide. I'm not going to talk about all of this. This is that third important protocol policy that you need to think about before reopening and set a plan for. What do you do about when this person can return to work? You need a return to work plan. Basically, what I've done here on these next 2 slides is provided, as of just recently, the CDC's recommendations for when an individual, non-healthcare personnel, I think I want to just point that out, it's important because that's different. But for an individual, non-healthcare, who was positive or had close contact with someone who was positive, when they may safely be around others. This recently changed. Let me try and simplify this for you as an employer. You're not an epidemiologist. We don't expect you to understand deep dive into health issues. There are 2 strategies for when someone may return to work according to the CDC. There's a symptoms-based strategy and a test-based strategy. Clear and simple, the symptoms-based strategy would require someone who was positive to be out of the workforce for 10 days and have absolutely no symptoms of the virus before they can return to work. A test-based strategy is exactly the way it sounds. It would be when you require, as an employer, you require tests. It used to be, up until just a couple of weeks ago, that the CDC's recommended, you can go to the next slide, please. Recommended test-based strategy was 2 negative tests with at least 24 hours between them before someone was safe to be around others. The CDC has just come out and said that they've seen instances where people are still testing positive weeks and weeks after they no longer exhibit symptoms of COVID-19. So they've been changing their guidance based on some of this. And so what we suggest for you as an employer is to take a risk evaluation of what works for you, your employees, your client base. Do you have clients? Are your clients an immunocompromised population themselves? Let me give you an example of something the CDC has said that you can do, but your business may not wish to do. They've said that if someone in your workplace tells you that they've been in close contact with someone who is COVID-19, but that individual themselves has within the last 3 months themselves had the virus, and they're not displaying any symptoms, you may, if you so wish, permit them to come back to the workplace without any quarantine or isolation. Now, that's not something that you may wish to do. This is where this comes down to that risk evaluation for what works for you, what makes you feel comfortable. I will say that we do think it makes sense that you require employees to give you a healthcare note from a doctor saying that they're symptoms free or that they've gotten the 2 test results. You can ask for the test results, or a note saying that they've gotten the test results. And those conversations obviously will be taking place while they're still outside of the workplace. And you know, you're going to want to have a policy, but you're going to have to deal with this person by person in terms of what the particular facts are, whether they're immunocompromised, etc. So something, lot to think about there, but very important to have in place because you don't want to be making it up on the fly. Next slide, please. And the last pillar, cleaning, disinfecting, and hygiene protocols. You'll have to go ahead and put these into place. Some of the cleaning and disinfecting stuff might require you to coordinate with others. Perhaps there's you're a tenant in a building and you pay, as does the rest of the building, for housekeeping. This office place safety standards require cleaning logs. So there may be some need for you to speak to your landlord or speak to the housekeeping company. And so, you know, high touch areas will need to be cleaned frequently. You can also put some of this on your employees, certain things that they'll need to clean, clean as they go, empty desk at the end of the day, different ways that will work for your business. Next slide, please. Okay, so we've gotten to that place, that enviable place where you've got your control plan in place. You have communicated it to your employees to the extent of what they need to know. You've trained them on what the safety standards say they're required to be trained on. You've affixed your attestation poster so that it's visible to all, and you're ready to reopen. One thing that we've been getting a lot of questions from employers about is how much of this can I share responsibility-wise with my employees? And we think that that's a great question, and we think that you can share quite a bit of the responsibility with your employees, because as we know, this virus is believed to spread person to person, so we're only as strong as our weakest link. We need participation of all in the workplace. You probably have, or some of you may have, handbooks where your employees sign an acknowledgement that they've read and they understand the handbook, that they're an at-will employee, and all that good language that we often counsel our clients on. Well, we see this as just as important as acknowledging any other policy. Having employees sign on that, yes, I've read the safety standards. I understand what you're asking me to do. I won't come into the workplace if I've tested positive or if I'm waiting for results. I won't come into the workplace if I've had close contact with someone who has tested positive. I will let you know. I will abide by, and Mark's going to talk about this, some travel restrictions if your business has them in place. And yes, I do understand that my performance may be impacted by a failure to abide by these requirements, up to and including termination, as we often include language-wise in some of these acknowledgements. May seem harsh, maybe it's not going to fit your business, but at a minimum, having that buy-in, I think, gets you a lot of bang for your buck. And that's what I've got today, and I'm going to turn it over to Mark.
Thanks, Kathleen. Now, in planning employees' return to the workplace, along with establishing a return to work plan, we've had a lot of clients revisiting their workplace policies. We've seen some areas where clients are updating policies, such as with telework, now that working from home is more prevalent than ever. There are other areas where clients are introducing temporary COVID-specific policies. This may involve establishing a sick leave bank or allowing for additional leave related to childcare. For these temporary policies, you should be sure to include language making it clear that the policy is temporary, and in most instances, the policy should not go into your employee handbook. Rather, it should be distributed as a separate policy. Recently, we've been fielding a lot of questions about establishing temporary travel policies. you've probably heard about Governor Baker's order regarding travel to most of the country and the need to quarantine upon returning from restricted areas. This has led clients to ask us, well, what should we do about employees going on vacation? Some employers are establishing temporary policies putting restrictions on leisure travel to areas that are not part of the lower risk states. Others are advising employees that if they do travel to the restricted states, they will have to quarantine for 14 days. Really, what you do all comes down to a business decision of the company on how to approach employee travel. I would note, however, that the website housing information on the travel order strongly discourages employers from requiring or allowing business-related travel and urges employers to strongly discourage their employees from taking leisure travel to the restricted states. Now, whether you establish a travel policy and the type of policy you establish is going to depend on the circumstances of your company, your workforce, and what you feel most comfortable with given the travel order. Next slide, please. All right, so you have your return to work plan ready. You've updated the policies. What's next? Well, you need employees to come in and work, right? So the company reopens the office and tells its employees it's time to come back to work. What happens if they refuse? Well, if that happens, the first question is going to be to the employee asking why they don't want to return. Does it have to do with the employee's own health? Does it have to do with the health of their family member who they live with? Is it a childcare issue? Do they have just a generalized fear of COVID? One of the things we were seeing a lot was after the CARES Act passed, employees were refusing to return because they were making more money on unemployment with the additional $600 pandemic unemployment assistance than they would if they returned to work. So what we're doing by asking these questions is trying to figure out if the employee's reasons for refusing to return to work is somehow protected. If, for example, the employee has an underlying health condition that would make them more susceptible to COVID, then you may have to engage in the interactive dialogue and try to work towards a reasonable accommodation in compliance with the Americans with Disabilities Act. If an employee is just, generally scared of COVID but doesn't have a medical basis for the fear, then the refusal may be unprotected and you can decide what to do with that employee, depending on the circumstances. The most important takeaway here, though, is that you shouldn't just outright dismiss an employee who says they can't return to work. You should work to figure out the reason for not returning, and from there, you can determine your approach. Next slide, please. Now, the approach to an employee's refusal to return may be dictated by their qualification or lack thereof for a protected leave. As mentioned, you may need to engage in an interactive dialogue under the Americans with Disabilities Act to assess whether there's a reasonable accommodation for the employee, which may include a leave of absence or a work from home arrangement. Those may be reasonable accommodations depending on the circumstances. Alternatively, the employee may be entitled to leave under the Families First Coronavirus Response Act. If, for instance, the employee has COVID or is caring for someone with COVID. I'm sure everybody remembers early on in the pandemic, you may recall receiving requests for leave for childcare purposes because schools were shutting down. This could still come up with schools set to reopen in the fall or even now with respect to summer camp closures. And if an employee has not exhausted all of their FFCRA leave, they may be entitled to a protected leave for childcare purposes if the child's care center gets shut down due to COVID. We also have the paid family leave law going into effect on January 1, which may be another source of protected leave for employees. And as you can see on the list, there's also FMLA you have to consider. There's sick leave. And then, even if the employee doesn't qualify for a protected leave, you may consider the employee's circumstances and the quality of the employee's work and decide that you want to offer the employee a paid or unpaid leave of absence. Now, if that's the case, you're going to want to make clear the terms of that leave and whether or not the leave's protected. In most circumstances, when you're providing a paid or unpaid leave of absence, that's not covered by one of the types of leaves up on the screen. It could be an unprotected leave, and you're going to want to make sure you include that mention of that in your correspondence with the employee. And in all cases, when we're talking about any of these types of leaves, we strongly suggest that you document all communications with the employee and any actions taken. For instance, if there's a need for an interactive dialogue, you'll want to document the back and forth with the employee, the accommodations requested and the accommodations offered, and reasons that any of the accommodations that the employee may have requested were denied. Next slide, please. The last topic I'll be going over is that overarching issue we talked about at the beginning, the duty of care. As you can see up on the slide, there's a general duty clause under OSHA, which requires employers to provide a place of employment free from recognized hazards likely to cause death or physical harm to employees. There's also the general common law duty to act reasonable under the circumstances. Throughout this presentation, we have been talking about ways employers in Massachusetts can satisfy this duty of care. We've been getting the question a lot about, how do I avoid liability as an employer when it comes to my employee safety? Well, essentially, what we want you to do is follow the guidance, follow the standards, and if you get any workplace complaints about COVID safety, take them seriously. Investigate the complaints and try to address the issue as best as you can. One option you may consider doing is establishing a safety committee charged with reviewing safety complaints, whether it be COVID related or not. Just a general safety committee is a good thought process or a good thing to think about putting in place. Also, just 2 quick points about OSHA. First is that OSHA has established guidance for reopening the workplace in light of COVID-19 that would be helpful for all employers to review. And we include a link to that guidance on this slide, and that'll be included in the PDF you receive, the link will be included in the PDF you receive after the webinar. Also, OSHA announced that there are recording requirements for recording cases of COVID-19 in the workplace. Now, there's particular reasons that you would or would not have to record a case or a report of COVID-19. So if there is a report of COVID-19 in the workplace, you should be sure to reach out to your employment attorney of choice. And if you have any questions about the OSHA's requirements, discuss that with them. Next slide, please. So, what a lot of this is about is we want to avoid a lawsuit claiming that the employer acted negligently by failing to take reasonable steps to maintain a safe workspace. This could come from many different angles. It could be a lawsuit brought by an employer an employee who claims to have contracted COVID at work. It could come from an employee's household member who claims to have caught COVID from the employee who caught it at work. It could be from a vendor visiting the work site who ended up getting COVID as well. Now, it's impossible to say, hey, we're going to not get any lawsuits, but what you can do now is minimize the risk of liability from a negligence or personal injury standpoint. And the way to do that is to be proactive. As I said, we want you to follow the standards, follow the guidance, establish a plan, and take employee complaints seriously. This will minimize your liability if any of these circumstances come up where an employee claims to have contracted COVID in the workplace. Next slide, please. And just one last point on liability. We've heard a lot of employers ask about whether workers' compensation will bar claims of negligence by employees. And frankly, at this point, it's unclear and will likely depend on the circumstances of the particular incident. Workers' compensation covers work-related injuries. With respect to communicable diseases such as COVID-19, they're covered only in situations where the hazard of contracting such diseases by an employee is inherent in the employment. So workers' compensation insurers may be hesitant to approve COVID-19 related claims where it's difficult to conclusively determine that the contracting of COVID-19 was in fact work-related. That said, if a worker contracts COVID-19 and the worker says that it happened at the workplace, you should be sure to file with your workers' comp provider and let that provider make the determination of whether it's going to provide coverage. There's not been any generally applicable legislation passed in Massachusetts to date that affirmatively states that COVID incidents in the workplace will be covered by workers' compensation. Some other states like Illinois and Wyoming have enacted legislation creating a presumption of coverage for certain workers. Massachusetts hasn't done this yet, and unless and until such legislation is passed, if workers' compensation does not apply, then employers may be subject to tort liability if an employee contracts COVID and claims that it occurred in the workplace. So again, be sure to follow the steps discussed here today to minimize that risk and to protect employees. And just one quick side note, there is talk in the Senate that the next stimulus package could include a liability shield for businesses. It's been introduced by Senate Republicans, and my understanding of reading, the bill and the rhetoric around it is that there's a lot of partisan pushback. So we're really going to have to wait and see if, that type of language makes it into any future stimulus package. And with that, I want to thank everyone for coming out to the webinar, and I'm going to turn it over to Kathy Rubin to begin the Q&A.
Just unmuting. Well, hello, everybody. Thank you, Mark and Kathleen, for this very high-level overview. We had some comments on the chat about, oh my God, there are all these requirements. The governor and the Commonwealth of Massachusetts have laid them out quite nicely. And, although Kathleen says we're not epidemiologists, if you just watch the news, everybody seems to be saying consistently that, if people just do these simple things, the hygiene, the social distancing, the various pillars that Kathleen talked about that are set forth in those guidelines, it really is going to make a huge difference for our country. So in addition to just you want to follow what the governor is telling us to do, these are all things that as a reasonably prudent employer, you're going to keep yourself safer, you're going to keep your workers safer, and it's going to be a net positive for the world. And I want to also note that all of these PowerPoint slides are going to be sent to you. We're also going to be sending to you a little checklist. Now, where this checklist comes from, this document that you see on the screen, when all these standards came out, we were getting a lot of clients who were just saying, I don't even know where to start. We put together this toolkit because Dave Wilson always likes to say, if it's not written down, it never happened. And what this is really a written plan, because if you've got a written plan that lists all these steps and is combined with employee acknowledgements and employee training, it can be easier. So we've developed this toolkit to help our clients create a written plan. We're going to provide the checklist, but the toolkit's designed for use with individual clients because, as was noted at the beginning, some of these standards are different depending on where you are, what city, what town, what industry. But that list, all those employees, all those HRW team members that you see with the little photos, these are our internal COVID-19 team. We formed an internal team that meets regularly to talk about these issues. And we get all the same questions from our clients about, well, this person wants to go to Ohio for a wedding, but that means they're going to be gone 3 weeks instead of 2 weeks. And can I really tell them, no, you can't go? And the answer is, well, yes, depending on your consistent policies and whether you've got it in writing, et cetera. So long story short, we are here to help. So now what we'd like to do is put if you have questions, put them on the chat and we will try to answer them in real time. I do want to comment that we are getting a lot of questions along the lines of, well, employees are just going to lie. And that has been an issue all over the country, particularly with very low wage workers, where they feel sick, but they're not going to tell their employer because they know if they tell their employer, their employer may not pay them, notwithstanding what Mark said about, but there's FFCRA leave, there's Massachusetts sick time. And we want to encourage all of you to try to create a work climate where people are incentivized to tell you, because that's going to make things safer for everyone. And putting that in writing, that not only are you required to come forward, we'll keep it confidential. We have these various options so that it's not going to be job threatening for you. Because if you just keep those folks out of the workplace that have got the symptoms or have tested positive for the requisite time, that will make all the difference. Once COVID enters the workplace, it's hard to get it out, but keeping it out, it's going to be a lot easier. All right, so Dave and I are going to sort of take turns reading some of the questions and seeing what folks say. So I'll take one. Let's see. I've heard mixed reviews on requiring COVID test results. I know as mentioned, employers can require the test results. Can you please confirm it? Or is it safer to just ask for a doctor's return to work note? Yes, you can require it. As Kathleen talked about, there's sort of a two-path you can take. One is you want to get them back earlier, get the test back. The other path is to wait the extended period. And some of our clients are saying, yeah, but what if they get the negative test? We don't want them back. Can we make them do the whole quarantine? And the answer is, of course, you can take reasonable steps to protect your workplace. We have other clients, particularly human service providers, who have staffing ratios, and they need that test to get the person back fast. And they take the risk that maybe it's going to be a false negative because they have a business imperative. And that's why we have the toolkit and we work with individual clients, because the answer that's right for one may not be the answer that's right for others. All right, and I'll also invite any of the panelists to read any of the questions that are coming up, popping up, and grabbing them.
Yeah, we had a lot of questions about privacy issues. And remember, here in Massachusetts, you have a right to privacy, but that's balanced against an employer's legitimate business interest in disclosing the information. So for example, with contact tracing questions, the employer is going to be able to use that information to protect everybody versus just worrying about somebody's individual rights. But when it comes to medical records and the like, you should still be protecting that information to the extent you can. And as our panelists told you earlier, if I, for example, come down with COVID, you don't announce that to everybody in the company. But what you do is you announce that somebody in your department has come down with COVID, or somebody who you have an office nearby has come down with COVID. That type of thing. Mark, Kathleen?
Yeah, I was just going to say, we had a question about if an employee who does not want to return to the office because of childcare reasons, do you have to offer them a reasonable accommodation? Would that be required? So that wouldn't be covered by the ADA. You wouldn't have to do a reasonable accommodation necessarily, but it could be covered by the FFCRA if they still have leave left under the FFCRA. There could be an FMLA implication there depending on the reason that they have they need to do childcare. It looks like the question's about lack of in-person school, but there could be other reasons that they need to be home with the child. So it's really going to be another one of those situations where you're really going to want to dig in to figure out what the real issue is. But the main one that pops up there is going to be FFCRA leave.
All right, we had a question. Will we be getting this as a recording? No, we are not recording today because we all agree to.
We are recording today.
We are recording today.
We are recording today, and I believe a link will be sent out.
Okay, so we'll talk as a team and let you know, but bear in mind that we will give out the PowerPoint. And for those folks who have individual questions, feel free to give us a call. If it's a quickie question about what did you say at X and such time, we'll be happy to share that. The concern for the recording, as we noted at the beginning, is that the information gets stale very fast. And so we just want to make sure that we're giving you the most up-to-date information. There is I see a question with regard to any sense that the hygiene requirements might be reduced, given the increased understanding by scientists that its transmission is mostly aerosols, it would make things easier for employers. We feel your pain, but we're not aware of any proposal afoot to relax those requirements. But as Kathleen noted, there may be some of these things that can be fairly delegated to individual people. You press the elevator button, you wipe it off. And so that will help things a little bit with some of that.
I did want to address, I answered in the chat, but I thought it was worth everyone hearing. Someone had a very good question about whether Massachusetts is requiring written policies. And my response is that yes, in a sense, they are requiring a written, and the word written is used, control plan that you have to save on the premises in the event of an outbreak or inspection. Now, with our clients, we've often made that control plan into full-fledged COVID-19 policies, like Mark talked about. But either way, you need something in writing. Like Dave Wilson always says, if it's not written down, it never happened. You'll want to waive that if that day comes where you have to deal with some sort of liability issue.
Here's a question that we're getting a lot of questions about travel policies. And the question is, if an employee is working 100% remotely and goes to a high-risk state for vacation, is it not an issue that they have to quarantine on return? And you're right, travel policies need to build in flexibility. If a person's working remotely, you probably don't care about them quarantining and you'd rather have them get back to work remotely as soon as possible. Some of our clients also build in flexibility. You know, someone needs to go to a high-risk state because a very close family member passed away and they want to be at the funeral. There may be a medical reason. There may be an imperative whereby you say, we're going to be flexible with the person who's traveling for a funeral, but the person who just chooses to go on a cruise and now is going to turn a 1-week vacation into essentially a 3-week vacation. Bear in mind that off-duty conduct, if a person engages in off-duty conduct that impacts their ability to do their job, employers will have some flexibility to deal with that, but you need to treat people consistently. You don't want to just leave this in the discretion of individual managers. You need to come up with some ground rules. Otherwise, people, you know, you're looking at a potential discrimination claim where some people are allowed to do it. And as one of the people who's been commenting on the chat has made the point that we don't want to give people an incentive to lie. So you don't want to be, you know, the person who tells you that they're going on vacation, they're cracked down on in a really draconian way. So they're just going to lie. That's not going to help you achieve the end game. And the end game, again, is we want to keep COVID out of our workplace. All right, so it looks like we've got what are the options for an employee who's exhausted their leave and not eligible for any other leave due to child care issue. This is one of these classic, you need to talk with your counsel. What if there's a collective bargaining agreement? If you've got a policy or uniformly enforced practice, if it's your absolute best employee, maybe you're going to be flexible with them. Maybe you're going to say, listen, we can't promise we're going to hold your position, but we'll let you stay out. We'll let you stay on the health insurance plan, and we'll do this consistently so that we can maintain our necessary staffing ratios. This really is one of these case-by-case questions. But ultimately, just like even if a person is absent due to legitimate reasons, once you've crossed off all the various types of leave to which they're may be entitled and you're treating them consistently, we have had clients who have ended the employment for employees who just cannot work due to COVID-19 issues. It's a hard thing to do. You don't want to kick somebody when they're down, but you at least know that in many instances, they will be able to collect unemployment. You may be able to rehire them. So discuss that one with your counsel.
And we've had many employers that have come up with creative ways where one spouse, she was a nurse working 7 to 3, and this gentleman usually worked 7 to 3 also. And instead, what the employer allowed them to do was work 4 till midnight. And that way the child care was covered and they could both continue to work. So, employers, a lot of it is having a discussion with the employee and see if there are creative options to allow everybody to win.
All right, on the question we had, and we'd prefer you use the chat rather than the Q&A, just because it's more clicking to find. But we've got a question that an employee is a note to stay out till X date, but a negative test result coming prior to X date. Can we have them return as a result of the test? So this is where Mark's talk of liability. Someone has got a doctor telling them to stay home, and you are making them come in against their doctor's orders. Now, suppose there's a COVID outbreak at your workforce. It has nothing to do with that situation. Everybody's going to think it's because of that situation. You're not going to look very good if you are encouraging employees to not comply with what a medical professional is telling them to do. I'll go out on a limb on that one. You know, and I realize there may be instances where a note is subject, you know, we all have had cases where people bring in a note and that note does not look like it's a legitimate note, or the note says something very vague. And you may have an opportunity to get more follow-up or to ask the employee to go back to the doctor. But I would be very wary about forcing an employee to violate doctor's advice. If that one goes south, you will have egg on your face. All right. Do we have to supply face masks, or can we require our employees to have their own? Do either Kathleen or Mark want to comment on that interesting question?
Sure. You don't have to require them. You don't have to buy them for them. You can require them, and you should require them. The safety standards mandate that you do. We do think it's a very good idea, however, to have a stash on site. I don't know about you, but I've run out of the house in the morning and just turned around and forgot a mask, or what we really should be calling a face covering, because a mask is a whole different animal subject to OSHA requirements. So face covering is the right word here, but you don't have to require it. Some employers do want to, though. We've seen this done different ways, a fund of some kind, you know, just thrown in a little check or in a paycheck. Or we've seen some branded, you know, by the company, which is kind of a nice little giveaway that you can give to your employees just to get them started. And other things that we've seen come up, the same old dress code issues. A mask shouldn't have anything on it that you wouldn't otherwise let an employee wear on a t-shirt. So, you know, nip those in the bud quickly when those kind of overreaching, or, you know, there's some interesting issues that have come up. There was a case filed against Whole Foods, actually, with regard to whether their employees could wear masks that said Black Lives Matter on it. But generally, if you look at your dress code policies and abide by that, you're probably in a good place. If you do have a question about a Black Lives Matter or something high button voltage issue like that, you should definitely reach out before making a decision.
So by 9 o'clock, we are out of time. So I just want to, huge thanks to Mark and Kathleen. I have learned way more from them about this topic than I have taught them. And this was clear and very helpful, but I want to encourage folks, pick up the phone, send us an email if you have follow-up questions, and keep, you know, hang in there, because you are at the front lines of keeping our country safe. And we appreciate all that you are doing to keep our economy going, keeping the workforce safe, and staying compliant and fair and consistent.